In 2014, the Chief Justice of the United States Supreme Court wrote something that had never appeared in a court opinion before. He wrote that your cell phone holds the privacies of life, not some of your private information, not a portion of your personal data, the privacies of life. Everything. Your medical records, your financial history, your location for the last 3 years, your conversations with your spouse, your doctor, your attorney, every photograph you have ever taken, every search you have ever made, all of it, on one device, in your pocket right now. And here is what that Supreme Court ruling Riley versus California actually means for the moment an officer leans through your window and says those 6 words. I'm going to need your phone. Most drivers hear that sentence and reach for their device without thinking, because cooperation feels like the safe choice, because showing the officer you have nothing to hide feels like the fastest way home. And that instinct, that decent, cooperative, completely human instinct, is the single most expensive mistake you can make at a traffic stop in 2026. I am Marcus. On this channel, I give you the real law and the exact words before you need them. I am a legal educator and commentator, not your attorney. This is education, not legal advice. Laws vary by state. Always consult a licensed lawyer for your specific situation. In this video, I am going to walk you through 5 specific things that happen after those 6 words and the exact response that protects you at every single stage. Stay with me through all 5 because the last one is something almost no other channel has covered, and it is the loophole officers are using right now to get around everything Riley was supposed to protect. Why your phone is the new target here is something most drivers never think about. 20 years ago, when an officer pulled you over, the information he could gather from your person was limited. Your license, your registration, your insurance, maybe a glance at what was visible inside your car. Today, you are carrying a device that contains more personal information than your home, your office, and your filing cabinet combined. Your phone knows where you sleep. It knows who you called at 11 p.m. last Tuesday. It knows what you searched for at 2 a.m. It knows your bank balance, your prescriptions, your location history going back years. Officers know this too, which is why I'm going to need your phone has become one of the most commonly used phrases at traffic stops that have escalated beyond a simple violation. It sounds routine. It sounds like a standard part of the process. It is neither of those things. It is a request for the most complete picture of your private life that any government official could access, and it is being made at the side of a road, without a warrant, in the hope that you will simply hand it over. Your job in that moment is simple. Know what the law says, say the right words, and do not let cooperation cost you something the Constitution was designed to protect. Subscribe right now if you drive and you carry a phone, which is every single one of you, because what I am about to show you is the information that should be standard knowledge for every American. It is not. Tactic 1. I'm going to need your phone. Officers learn this one on day 1 of digital evidence training. The phrase is not a legal order. It is a request designed to sound like one. There is a meaningful legal difference between those two things, and the officer is counting on you not knowing it. Under Riley versus California, decided unanimously by the Supreme Court in 2014, officers cannot search the contents of your phone without a warrant, not during a traffic stop. Not during an arrest, not ever without a warrant signed by a judge based on probable cause. Chief Justice John Roberts wrote the opinion himself. He said that searching a cell phone is categorically different from searching a wallet or a bag. The scope of information is so vast, he wrote, that allowing warrantless phone searches would be like permitting a search of the person's home. So when an officer says, "I'm going to need your phone," he is making a request that the highest court in America has already ruled he cannot fulfill without judicial authorization. But here is the trap. Riley only protects you if you do not consent. The moment you hand over that phone voluntarily, cooperatively, with the best of intentions, the Riley protection evaporates. Courts have consistently ruled that voluntary consent eliminates the need for a warrant. You gave permission. The Constitution was not violated. Case closed. Your response is calm, clear, and immediate. Officer, I do not consent to a search of my phone. If you have a warrant, I would like to see it. Say it once. No apology. No explanation. No, but I have nothing to hide. Those words documented on his body camera activate Riley and place the legal burden back where it belongs, on him. Tactic 2. Just let me see it for a second. This one sounds like kindness. It is strategy. After you decline, many officers will soften the request. I just need to verify you weren't texting. I'm not looking at anything else. It'll take 5 seconds. Picture a man named Dennis, 60 years old. Never been in trouble a day in his life. He was not texting. He is certain of it. And the officer's casual reassurance, just a quick check, makes refusing feel unnecessarily difficult. Dennis hands over the phone to prove his innocence. The officer spends 3 minutes scrolling. He finds a text thread. He uses it to justify extending the stop. Dennis spent 2 hours on the side of the road that night over something that had nothing to do with his driving. Here is what Dennis did not know. Even if the officer's stated purpose is narrow, once you hand over the device, there is no legal limit on what he can observe in plain view on that screen. A notification that appears, an app that is open, a message thread visible when the screen illuminates. All of it becomes fair game the moment the phone leaves your hand. Your response does not change based on how reasonable the request sounds. Officer, I do not consent to a search of my phone. Same words, same calm. The friendliness of the request does not change your legal position or your response. Stay with me, because tactic 3 is the one that catches even the drivers who said no to the first 2 requests. It is the move that comes after you have done everything right, and it is the reason I told you to stay until the end. Subscribe right now if this is changing how you think. This channel covers one situation every week that you will not find explained this clearly anywhere else. Tactic 3. The biometric trap face and fingerprint. This is the most important section in this entire video. You said no. You invoked Riley. You did not hand over the phone. The officer pauses. Then he reaches for your device and holds it up toward your face. Or he takes your hand if you are outside the vehicle and presses your thumb against the screen. This is the biometric loophole, and it is the one that most channel creators have never explained properly. Here is the legal distinction that makes this so dangerous. The Fifth Amendment protects what you know. A passcode is knowledge. Courts have generally ruled that officers cannot compel you to provide a passcode because doing so would force you to testify against yourself, a direct Fifth Amendment violation. But the Fifth Amendment does not automatically protect who you are, your face, your fingerprint, your physical identity. Courts in several jurisdictions have ruled that biometric access, because it does not require you to reveal knowledge, may not carry the same Fifth Amendment protection as a passcode, which means the officer who cannot legally compel your 6-digit code may attempt to use your face or your thumbprint to bypass that protection entirely. Your verbal response when this happens, officer: I will not provide my fingerprint, face, or voice to unlock my phone. Say it clearly. Say it for the camera. And then, and this is the action step I need you to take before you ever get back in your car, disable biometric unlock on your device right now. Go into your phone settings today. Turn off Face ID. Turn off fingerprint unlock. Set a strong alphanumeric passcode instead, because a passcode cannot be physically bypassed by pressing your hand against a screen. Your face cannot be covered, but a long alphanumeric code requires your cooperation. The Fifth Amendment says you cannot be compelled to provide. This single setting change is the difference between Riley protecting you completely and Riley protecting you with a loophole the size of your own face. Tactic 4. We already have access through the carrier. This one sounds like the fight is already over. The officer or a second officer who arrives at the scene tells you they can pull your phone records directly from your carrier. So refusing to unlock the device is pointless. Here is the legal reality behind that statement. In 2018, the Supreme Court decided Carpenter versus United States. The court ruled that accessing historical location data from a cell carrier requires a warrant. Chief Justice Roberts wrote the majority opinion and cited the Riley ruling directly. The court held that you retain a reasonable expectation of privacy in the whole of your physical movements, your phone records, with precision every moment of every day. What the officer is suggesting, carrier access without judicial authorization, is exactly what Carpenter was designed to prevent. Your response, officer: I do not consent to any access of my phone or my phone records. I am invoking my Fourth and Fifth Amendment rights, and I will not answer further questions without my attorney. You are not arguing. You are not challenging him to a legal debate on the shoulder of the road. You are documenting your position on camera. You are creating the record your attorney will use. Tactic 5, the silence trap. What happens if you say nothing here is the mistake most people make when they decide they simply will not engage with any of this. They go quiet, they cross their arms, they stare forward and refuse to respond. And the officer writes in his report, subject was evasive and uncooperative when asked about phone. Behavior consistent in my training and experience with someone attempting to conceal evidence. In 2013, the Supreme Court decided Salinas versus Texas. The court ruled that simply going silent without explicitly invoking your Fifth Amendment right is not legally protected silence. Your unannounced silence can be characterized as consciousness of guilt. Prosecutors can and do use it in court. Read that again, because it changes everything most people think they know about staying quiet. The right to remain silent is not automatic. You have to reach out and claim it, out loud, in words, which means the answer to "I'm going to need your phone" is never silence. It is the exact sentence I gave you, stated calmly, stated clearly, stated for the body camera. Officer, I do not consent to a search of my phone. If you have a warrant, I would like to see it. I am invoking my Fourth and Fifth Amendment rights, and I will not answer further questions without my attorney. That sentence does what silence cannot. It invokes your protections explicitly, it documents your position permanently, and it puts the legal burden exactly where the Constitution places it on the government to obtain judicial authorization, not on you to prove your innocence at a roadside. Rapid summary, run it back. Tactic 1, I'm going to need your phone. I do not consent to a search of my phone. If you have a warrant, I would like to see it. Tactic 2, just let me see it for a second. Same sentence, same calm, no variation. Tactic 3, biometric attempt. I will not provide my fingerprint, face, or voice to unlock my phone. Then disable biometrics on your device today. Tactic 4, we can pull your records from the carrier. I do not consent to any access of my phone or records. I am invoking my Fourth and Fifth Amendment rights. Tactic 5, the silence trap. Never go quiet without invoking out loud. Salinas says your silence can be used against you. The golden rule: comply with your body. Assert your rights with your voice. Fight it in the courtroom, never on the roadside. Your hands follow every lawful physical command. Your mouth gives nothing, consents to nothing, and stays calm from the first second to the last. The roadside is his home field. The courtroom is yours. And what you say or do not say in the next 60 seconds of a phone request determines what your attorney has to work with when you get there. Before you close this video, go change your phone settings, right now. Before your next drive, turn off Face ID, turn off fingerprint unlock, set a passcode that is not your birthday, because that one setting is the difference between the Supreme Court protecting you completely and an officer bypassing everything Riley was designed to guarantee. Then, share this video with one person who drives, your spouse, your adult child, your parent, because this is the kind of information that should come with a driver's license. It never does. Subscribe to Marcus Your Rights Explained and hit the bell. Every week I give you the exact words for the exact situations before they happen to you. Because that officer is counting on one thing above everything else: that you hand over the device before you remember you had a choice. After today, you remember. Stay calm, stay firm, stay polite. I am Marcus. I will see you in the next one.